can't be adequated with the act of ravishing by a stranger. Adolescent girls should control sexual urges, as in the eyes of society, she is the loser when she gives in to enjoy the sexual pleasure of hardly 2 minutes. Unbecoming of a woman to go to sleep after she is ravished. Wife should be minister in purpose, slave in duty, Lakshmi in appearance, earth in patience, mother in love, and prostitute in bed. So we know that India has a history of being patriarchal and sexist when it comes to issues of women, when looking at women. But what happens when our judiciary, which is supposed to be the highest neutral and independent body, also reflect this kind of patriarchy? So we've seen a trend where the judges, while deciding cases of women who've approached the court for relief, have been told these things and been denied their basic rights. So today we have Dr. Ashna Singh, who is going to decipher these judgments and also talk about what judicial conservatism and what is the impact of it on the notions of justice for women in our country. A little bit about Ashna. Ashna is a professor of law at NLSIU. She works on the constitution and caste-related laws, and she's also a researcher. Over to you, Ashna.
Can all hear me, no? Okay, get right into it. Right.
Can you see the slide?
Okay, so I'll start with, but before that, what is that judgment that came today?
Oh yeah, the latest one was that
Calling half an hour ago.
yeah, we were just about to prepare this place, and we saw a judgment of Patna High Court where they set aside a 498A conviction, which is basically cruelty by husband or his family. It's a criminal penal offence. So the judge set it aside by saying that calling your wife bhoot or pishash does not amount to cruelty.
Yeah. So, okay, so with that, let's first look at what our constitution actually says about women. So there's Article 14, 15, 16, which forms the corpus regarding the right to equality. There is Article 21, which is right to life. Article 15 allows the state to, create special measures for the advancement of women and children. And there is CEDAW, which is the Convention against Elimination
All forms of discrimination.
all forms of discrimination against women. Yeah, thank you. So, in that, there is an obligation that state parties are required to modify or transform harmful gender stereotypes and eliminate wrongful gender stereotyping. So, now the idea is that this is not an exhaustive list, first of all, but you can say that this is like a basic sort of starting point that we can begin with, and it's also to make ourselves aware of the fact that the constitution in itself doesn't intend to be harmful for women. It could be in by way of how it's interpreted by the judiciary, for instance, but it doesn't prima facie it doesn't intend to be so. So what is it that is going wrong when it's not a law per se that is oppressive? There have been oppressive laws in terms of the evidence law, even in criminal law, which have constantly undergone reforms and are undergoing reforms. So over there we see some sort of constant change taking place. But when it comes to the behavior of the judiciary, there's very little to say in terms of change. There are some few precedents here or there which are very empowering, but largely if you see, especially the lower courts and even the high courts, they tend to be fixated upon these stereotypes, and they use stereotypes to reason out the application of a law. And that is not something that the court is supposed to do. The court is supposed to stick to what the law is, the morality which is consisted within the law, what we call as constitutional morality. Go by what is the morality prescribed by the constitution and do not impose your own ideas of morality, especially about women. So when we firstly about stereotyping, so there's a definition of stereotyping which is given by CEDAW, which is that it is a generalized view of preconception about attributes or characteristics that are ought to be possessed by members of a particular social group, or the roles that are or should be performed by members of a particular social group. Now these can be positive or negative stereotypes. So for instance, a seemingly positive stereotype can be that women are nurturing, or they are compassionate, or they are clean, or they are organized. Something of that sort, which might seem to be, not really harmful. But what the point that I'm trying to make is that any kind of stereotype, whether positive or negative, can, have harmful outcomes, at least in terms of what narratives are said. So a lot of the times, courts will rely upon a positive stereotype and give a wrong judgment, or rely on a wrong stereotype and hence reach a wrong conclusion. So in any case, the role of gender stereotypes is something that we're trying to question here. And now this, when we come to the source of oppression, something already mentioned, we are not necessarily looking at the law itself as a source of oppression, but looking at how judges are reading benign laws in oppressive ways. So the impact of this is that it limits choices of women, abilities, growth of women, and their rights. So if you see the point that I've written there is that rights, women go there seeking rights in the court. But what the court ends up doing it is that the court will say, oh, but your duty is this. A duty which is not given anywhere in the constitution or any other law. For example, you have a duty to wear sindoor. And because you were not wearing sindoor, I am granting a divorce to your husband. Or something like that. Right? So when the relief is for the claim of a right, the court somehow transforms into the duty of a woman, and more so a duty of a wife. So relying on that conception of what an ideal wife is, what her duties are, based on that the court is giving judgment, instead of relying on what the rights of women, what rights of women are prescribed within the law, for example, the Domestic Violence Act, or the Indian Penal Code, or law regarding cruelty, etc. So now we've seen that stereotype is trying to establish that stereotypes exist. Now we also need to know why these stereotypes exist and where do they come from. So my sort of like the idea that I want to pitch in is that there's an ideological theoretical basis to where these stereotypes come from. It's not that stereotypes come out of thin air. All these stereotypes, at least gender stereotypes in India, are very dependent on the Indian context and the Indian society. And this is something that has been done in gender studies as well, that every society has been patriarchal, but the source of gender stereotypes, there's some variations. So I basically want to look at Manusmriti, at taking that as the base, and then looking at what gender stereotypes emerge from there and how they continue until today. Right. So the other thing is, somebody could say that why am I only looking at Hindu law and why not Christian law, Muslim law, Parsi law, etc. But it's also the case that we are in a country which, since ancient times, has the order that has been there, the law and order situation. It has mainly come from the Hindu law. Even in the public life, even in terms of criminal law, etc., the derivation is mainly from Hindu law and not from these other laws. And majority of the judges that you see are also Hindu, and they are male, and they are upper caste male Hindus. So therefore it makes sense to analyze what part of the society they come from and what are the scriptural similarities that you see in the statements that they make. So therefore it's not just about patriarchy, it's not just plain patriarchy that has come from somewhere, but I'm trying to locate where patriarchy is coming from in the Indian context and the Indian judiciary, which is the idea of Brahminical patriarchy. Now, Brahminical and Brahminism, it's not just to do with the Brahmin, but it has to do with an ideology which can cut across caste and cut across genders as well. So therefore, when you see in the media, there's always reporting about how this court gave a stereotypical view, the patriarchal view. But nobody is really questioning where is this patriarchy coming from, and does it have anything to do with the history of law itself, right? So the legal historical aspect that I'm referring to here is again the Manusmriti, which Ambedkar categorized as being the law of the land, and therefore that has impacted much of the socio-legal order in ancient times. And then when the Britishers came, and even in modern times, there's a lot that lot or a few things that now that our systems have been borrowing from Manusmriti. Then there is also the concept of graded inequality, which is again it's about to do with the caste hierarchy and how there are the four varnas and then the untouchables. But there can also be inequality in the status of, suppose, an upper caste woman can be higher than that of a lower caste man. The status of a lower caste man can be can be above a can be above a lower caste woman. In that sense, there's also cross-cutting inequality. It's not a simple vertical system of inequality, but there's also overlaps in terms of inequalities. So now, I want you to read this and tell me, do you see if there's anything that is substantially different in the two paragraphs, in the essence? You seem the same? Yeah, that's
They are not absolutely not.
why.
It is very apparent to me. Let's have a figure out.
But you,
So the first one is basically going to the very idea of what is termed as perpetual consent because of the marriage, right? That husband and wife, whenever they get married, the woman gives a perpetual consent without a power of revocation. And that perpetual consent, because of that consent, you actually cannot have rape per se. And that is exactly the question of marital rape. I mean, Delhi High Court's split according on this point itself. Like one judge is saying it should be rape because there's bodily autonomy, decision, agency of a woman. You see woman as a particular individual possessing the constitutional rights.
you are reading too much into
Yeah.
this.
No, but then on the other side,
No,
you
just
basically.
think in terms of stereotypes.
Yeah, I mean, one is that as a wife, she cannot go against the husband. There is perpetual consent. The second one is again the very idea of stereotypes per se. That though he may be bereft of worship, given to lust and totally devoid of good qualities, a good woman should always worship her husband like a god. This is something that is ingrained inside at least Indian women in the north. That Pati Parmeshwar, Pati Devta and all that. That the husband can do no wrong. So you have to kind of always be subservient. For instance, your idea is that you have to be subservient to the husband. So 1 and 2 are basically corollary of each other.
They are correct. You agree with that? Yeah, but that's the point. The first paragraph that was said by a judge. The second paragraph is from the Manusmriti.
Okay.
Samvik actually pointed that out. I don't know what she
Okay.
said.
So therefore the
Nice.
conclusion is also wrong and the stereotype that is applied is also wrong, and the stereotype is again not coming from the west or from, I don't know, from certain parts of the country, as we assume that such ideas only can come from Bihar, that is a stereotype. But this is from all across India, from courts all across India. This is not concentrated in North Indian courts or anything. This is South India, North India, East India, West India, everything. So therefore
Basically Indians.
this the conclusion that the court came up with was wrong, and the stereotype that it also applied was wrong, which is that basically the court said that this is not rape. So now if you see this one, now here the court arrives at the right conclusion, but read this and see how the stereotype is still incorrect, or I mean there should be no stereotypes at all. Basically his complaint was that she doesn't dress according to my liking, she doesn't get up before I have to go to office, she doesn't make breakfast for me, lot of other little things that his complaint was.
Just don't beat her.
Yeah. So the court is kind of become a mediator now. Instead of applying what the law is and deciding if this is cruelty or not, the court is like, okay, fine, you do this, both of you come halfway. So the court is kind of becoming this family, he becomes this family guy who's trying to resolve the dispute extra legally.
Panchayat basically.
Yeah. Modern cup. Now, this is regarding sexual offences. You can see The sentence of the rape convict can be cut if he agrees to pay rupees 1 lakh to the victim. In another case, the judge is saying, if you marry her, we can help. If not, you lose your job and go to jail. And he's like, I can't marry her because I'm already married. And the judge is repeatedly asking him, but you will go to jail. You have to marry her. Like the suggestion that he's giving, firstly, it's like completely wrong and also illegal because rape is not a compoundable offense in the sense that you cannot come to a compromise when it comes to rape cases. A rape case necessarily has to undergo trial before the court, a criminal trial. So it cannot be mediated in this way. But look at what the courts are doing. Then one rape accused wanted bail, and the judge basically said that tie a rakhi to the victim, and promise that you will not do this to her again, and you'll be like her brother. Okay, so these are the kind of remedies and grounds that the court are deploying in order to give relief to the rape accused. Okay, so
Not to say for the second one, the court is actually asking him to do another crime of bigamy.
yeah, exactly.
So
yeah.
that would be like double.
Two marriages, which is
Offenses.
again not allowed.
Again, depends on religion.
Still, they're not necessary.
Yes.
They-
As per personal laws, different religions allow.
But rape is not.
Yeah, I agree.
Okay, then we see some emerging politics of sindoor. So,
Politics of sindoor.
so there is
Nice.
so these are again these are two cases. None of them are relied on each other. Okay, so in a common law system that we have in India, the court, even if it is to do with a very bad precedent, the court will generally rely on a precedent and say that this court has said this, so therefore I can't do anything. I have to follow the rules set by this court or a higher court, and therefore I am giving this. I have to give this judgment. But in this case, both of them have not relied on each other. That one came first and this one came later. So the second case has not really relied on the first one. So you can see how these stereotypes are coming from their minds, and they're not necessarily, they're not even legal in the sense of law, in the sense of following precedents, but they're going on setting precedents in this way. You can see refusal of applying sindoor, not wearing these bangles are sufficient basis to grant divorce, whereas we saw that that was not enough to be called as cruelty, calling your wife ghost and something else. When the statement of the woman was recorded in the court, she admitted she was not wearing sindoor. This is a very recent, came out last month itself in Indore family court judgment. Sindoor is a religious duty of a wife, and it shows that the woman is married. She has forsaken her husband. She is not wearing the sindoor. So this overemphasis on sindoor and saying that this is her duty, and based on what her traditional duty is and his idea of morality, the judge is saying that you cannot have your right because you are not upholding your duty or your dharma. Then look at this one. So this is also about again how the court is bringing in Hindu traditions and saying that wife is supposed to be one with her family, and if she refuses to live with her in-laws, it would amount to cruelty. And huh?
हम आपके हैं कौन?
Yeah.
Yeah.
Yeah. Which one?
Mr. Parjapati has done a lot of harm.
In India, generally people do not subscribe to Western thought where people upon getting married or attaining majority, the son gets separated from the family. In normal circumstances, a wife is expected to be with the family of the husband after the marriage, and she becomes integral to and forms part of the family of the husband. Now see this one.
I read this one.
So this was again very creative but extremely wrong reading of a fundamental duty in a constitution, which is that when the intention was to preserve a rich heritage, composite culture in terms of at most like Diwali, Holi and things like that, and not something like this. I mean, you can't. This is again, very distorted reading of a fundamental duty. Yeah. So, for example, when the Hindu code bill debates were going on, they were far more progressive because in that they were saying that there's a directive principle of state policy, as in the state is supposed to fulfill certain things, certain mandates the state has constitutionally, which are not enforceable. They are the state can take its own time to fulfill them, but it's like a charter of duties for the state. So the state is supposed to ensure that there's no concentration of wealth in like one or few sections of the society. Now the Hindu Code Bill read that provision in the directive principle to say that women should be given property rights because otherwise it leads to the concentration of wealth in one particular section of the society, which is basically men, and which is basically upper caste Hindu men, right? So you can see the interpretation of a constitutional provision there and the interpretation of a constitutional provision here. This is also fairly recent. I think this case was from last year or this year only. You can see that was 1940s, 50s, and this is 2023-4. That this is how judges are interpreting the laws, which is why I said that it's not the intention of the law that intention of the law is not necessarily to oppress women, but law is constantly undergoing transformation to empower women. But the judiciary is going in the completely opposite direction. Now read the last this para. Now this is a woman should not try to separate herself from her father, her husband or sons, for her separation from them would make both her and her own and her husband's families contemptible. Now this verse is from the Manusmriti, okay, and this is all what courts have said. So again, do you see any fundamental difference between the two in terms of what the gender stereotype is or what the duty of the woman or basically the wife is in this case? Now if you look at this one, now again a benign reading of this is what the judge has said, the first para. The second one is also what the judge has said, but he's quoting from Manusmriti. So in the first para, he's saying crime of rape can be regarded as the highest torture inflicted upon womanhood. It is less a sexual offense than an act of aggression aimed at degrading and humiliating women. Now somebody might think that there's nothing wrong in saying this, right? Somebody might also say that there's nothing wrong in saying the second para, which is that where women are honored, divinity blossoms there, and where women are dishonored, all actions, no matter how noble, remain unfruitful while granting compensation to the rape victim. So basically, in Rajasthan there's a victim compensation scheme for rape victims, and the court rightly reached the right conclusion, but again employed a wrong stereotype. And this is wrong because again, when we speak of gender stereotypes in judiciary, even the gender stereotype handbook that the CJI released, I think this year or last year? Last year, yeah. So in that also they're saying that you should think of rape not as something that is loss of her honor. Rather, you should see it as a violation of her bodily integrity and autonomy, right? So therefore, to add these extra things that this is shame upon her and so sad and so humiliating for her and so degrading and this and that, and again it's perpetuating a certain idea of woman's honor, a woman's body, and in that sense these stereotypes can again be harmful. And then looking at taking something like this from Manusmriti, taking it completely out of context, because this verse for instance is about again the duty of a wife. So the idea is to keep the wife as controlled as possible so that she can be happy in that caged environment and fulfill her duties properly. So that's the premise of this verse in the Manusmriti. So to pick it out of context and to say that there's beautiful things in Manusmriti or something like that is also very problematic. Now if we look at this one,
Oh, I know the first one.
yeah. Anybody, what case?
Vishaka.
Yeah, Mangri baby.
Probably baby, yeah. And then taken up by Vishaka. So this is another stereotype which the court has said a higher caste man cannot rape a lower caste woman for reasons of purity. Her husband could not have watched his wife being raped. Men who are 60, 70 years old cannot commit rape, and one relative cannot commit rape in front of another relative. Yeah. So sorry, I'm conflating Manu's verses with judgments now. That's part of a judgment, and this is a verse from the Manu Smriti, which is that basically.
That's also how judges write the judgments.
Yeah,
With the mind and constitution in the hand.
Exactly. Yeah. So even I'm also overtaken by that now. But Anyway, Manu promotes this idea that for the upper caste male, all the women below him are open for sexual uh, activities. Exploitation. Yeah. So that's the hierarchy that is there, and you also see at first marriage a woman of equal class is recommended for twice born men. So anyway, the court is relying or not relying on the stereotype, I don't know, but basically it's okay for an upper caste male, according to the Manusmriti, to devour any woman he likes. And then the court is saying that, but a higher caste man cannot rape a lower caste woman for reasons of purity. Both of these things are highly questionable.
The second one is basically about endogamy.
Okay.
No, that's not important.
To an extent, endogamy, as in you basically marry
There's endogamy and
within
then
your own varna, but there is also
Yeah.
hierarchy based on both basis of caste and gender.
Yeah, and there's also provisions for sexual pleasure of men,
Yes.
and this is part of that. Yeah. So this one, so you can see here.
That was Phulan Devi, no?
Yes, that was Puran Devi.
Uh,
So she was also raped by Thakurs, which was
and she killed them.
then she killed.
Yeah,
Yeah, that one is.
is related to Gauri.
Yeah. So anyway, this is just to highlight that there are that a woman's caste also has to do a lot.
She fought for Mirzapur in 96 and 1.
Yeah.
That's my constituency.
Okay, so I'll read this. These witnesses are ignorant and illiterate women belonging to scheduled tribe, and it is extremely doubtful if they could speak of age with precision. It was to do with some evidences before the court. The victim was a shocking liar whose testimony is riddled with falsehood and improbabilities. This is a very famous Mathura rape case where the police itself basically raped this underage girl. Yeah, and after this, some legal reforms came about many years later, which is to do with stricter punishments for police officials. This last part, the last para, is from Manusmriti, from a version of it. Hunting, gambling, sleeping by day, malicious gossip, women, drunkenness, music, singing, dancing, and aimless wandering are the group of 10 vices born of desire. This is also about women. So this is again to put forth the idea that women have been seen, according to our society, as being inherently incapable of telling the truth, and they're inherently liars, they're inherently gossipers, they're inherently promiscuous, they're inherently lustful. So, and the entire point of Manusmriti is basically to tame her sexuality, to put her in the role of a wife instead of letting her be a woman. So the Manusmriti speaks a lot about, gives a very high status to a wife as compared to a daughter or a sister or a mother, right? And this is different from how societies, when societies were much less organized, motherhood was given privacy. But then what would happen is that because you give motherhood primacy, her sexuality was also given privacy back then, because the important goal was to have a child in whatever way. Reproduction was valued. But later on, what happened was that her reproduction came to be controlled. So caste is not just a system of production, but it is also a system of reproduction. So anyway, this is the stereotype that we get from the Manu, and these are the stereotypes that the court has employed, especially for women who have been marginalized. And we can also see how it is when marginalized women have undergone the worst of atrocities in India is when major legal reforms have taken place. For example, the Mathura rape case. For example, the Manvari Devi case, which is popularly now Vishaka. The sexual harassment law that we have is because of that case. And the stricter punishments for police officials that we have is because of the Mathura rape case, who were all marginalized women. Yeah. Now, again, if you look at this, Uh,
First time I'm looking at this.
Yeah, so this is basically to again bring about the idea of what an ideal woman as a victim, as a rape victim or a victim of sexual offences should be like in order for the court to be able to give her the right relief. So why the victim had gone to her office at night? Why had she not objected to consuming drinks with him? Uh, she was tired after the rape and fell asleep. That is unbecoming of an Indian woman. That is not the way our women react when they are ravished. Now, this term ravished is also something that the Gender Stereotype Handbook has suggested to be replaced, that you cannot use words like this. Judges cannot use words like ravished and lose character, etc. Survivor should have attacked the appellant like a wild animal, but the fact that she did not even resist suggests that there's nothing other than consent. The photographs produced along with the bail application by the accused would reveal that the complainant herself is exposing to dresses which are having some sexual. The English is really bad. This is how the judge has written it. This is like verbatim, but the idea is that basically trying to make a point that because of the way she was dressed, something the provocation
She was
came from
asking
there.
for it,
Yeah, she was asking for it. Then this is a verse from the Manu. Women are innately promiscuous, fickle-minded, lacking in love, unfaithful to their husbands even when closely guarded. And there are other verses which basically talk about how women, are the ones who, when somebody is meditating, for instance, a man is the one who's the meditator in the society, and how she comes and with her beauty, yeah, she distracts him. So there are so many verses related around that, and this is again to tell us that the woman's nature, her inherent nature is wild, uncontrolled, fickle-minded, promiscuous, this and that, and this is something that we see guiding our judges even today. That there is this lack of faith in a woman's testimony. When a woman is testifying something, there are so many additional questions that she's asked, and this is there's also this evidence law reform that happened because of this, because there was constant questioning about her sexual behavior, her past sexual behavior, and there was also something called this two-finger test, which used to take place, which was very recently disallowed, which is basically that if the doctor is able to insert two fingers into a woman's vagina, that means that she was sexually habituated to having intercourse, and therefore she's a promiscuous woman, and therefore the act in question now cannot be rape. So that is again something that the court, after many years, had to say that this is what kind of a test is this, and what kind of a stereotype is this propagating. How can you say on the basis of a two-finger test, which is not even it is not a scientific method or a scientific test to check if somebody's been through rape or if somebody has been sexually active before.
Yeah, but it's still continued even today in practice.
And it's used as evidence?
Yeah. It's in the MLC. It still happens. It's held as unconstitutional and illegal, but it's
For a very long time it's been held as like undignified manner
2024.
to treat survivors of sexual offences, but it still happens.
It's not allowed
But
formally.
it becomes a court document is what you're
Yeah.
saying. Like
They're doing it.
We
2024
had-
rape case, it's done. And
Because it is also this that the doctors are
they don't have awareness, that's true.
yes, and the secondly they look everything very technically. So see, at the end of the day, when how you apply the law is that the fellow who is doing the test. I have friends who are doctors, both males and females. What they told me is, we can't read all this jargon. You tell us what to do, we'll do it properly. Now there is this one idea that this all tests have been continuing for a very long time. Right, so you telling okay this constitutional, unconstitutional, see again the very idea of practice is just because it has continued for such a long time, it will continue unless there is obviously a lot more resistance from the
So,
other spaces.
a lot of the times, a lot of laws are read down, like 66A in the IT Act, but it
Yes,
will
well, yeah.
continue to be applied by police in charge sheets and even by lower courts until unless it would go to the highest court, and there they would say, but this has already been read down or this has been deleted from the law and this cannot be applied. So you can see how much of waste of time it is also for the judiciary, but this happens. Now this one, this is also very recent judgment. We're living in the 21st century, and in the past, girls would attain motherhood at an early age. This was regarding an abortion case. The first child would be born by the age of 17, girls, and this was an underage girl who had been raped, and she was seeking this plea for abortion. And a lot of times, the woman doesn't know that she's carrying a child, and by the time she realizes, the
24
the
weeks period.
yeah, that period is already gone by where you can do abortion on your own. After which a medical board etc. has to be set up, and they have to verify whether and only in certain circumstances that abortion is going to be allowed, like in case of a serious birth defect. So girls mature early than boys. 4 to 5 months here and there doesn't make any difference. You will not read it, but do read Manusmriti for once. The judge is telling the lawyer, the lawyer who's representing this girl, that you should read and not make such a fuss about it. So
It's reported in one of the like live law or something, and then or was it even in the judgment? No.
it was expunged.
Ah,
So the judge had to remove this. I mean, from the order, this had to be removed. Something like that had happened. Yeah. So again, this is also fairly recent incident.
Which series is this? The picture?
This is Balika Vadu.
Oh.
So the judges are basic. I mean, there are other things that the judge, in other cases, judges have said that please marry the victim. So that's why that. But yeah. But now you can see how Manusmriti is being quoted explicitly. Earlier you could see there were gender stereotypes which you could say have parallels in Manusmriti, but now they're openly, overtly, yeah. Yes, they're drawing from Manusmriti. Yeah, yeah. So they're quoting Manusmriti left and right, and they're not even giving any proper citations for it, or from which verse of Manusmriti or from where they have borrowed. They've just, I think they also just Google and
See, it is just all in the mind of them.
yeah.
You need,
They don't need to, I think,
Yeah.
refer to Manusmriti.
for
It comes
example,
from there.
when you actually are, let's say, citing a fundamental duty, there is a fundamental duty basically saying, as a citizen, you should basically give away all the practices which are derogatory to women and offensive to her dignity. Now that is not used. What
Instead,
is
what is getting used is the woman to
Yeah.
protect the age-old Indian culture of serving her in-laws and husband. Yeah. So this one, and this is,
This is Hadia.
yes, this is the Hadia case, which was very famous. One NIA panel and all was set up. Full investigation happened whether this was love jihad or not. So
Kerala.
yeah, Kerala High Court, and yeah, so now again, the first para is what the court has said. The second two are verses from the Manu. So a girl aged 24 years is weak and vulnerable, capable of being exploited in many ways. Her marriage being the most important decision in her life can also be taken only with the involvement of her parents.
This is from the court judgment.
Yeah, this is from the judgment.
High Court.
Yeah, Kerala High Court. And these two are verses from scriptures. Even in her own home, a female, whether she's a child, a woman, or an old lady, should never carry out any task independently. As a child, she must remain under her father's control. As a young woman, under her husband's. And when her husband is dead, under her son's. It is said to be the law of Brahma when a man dresses his daughter and adorns her, and he himself gives her as a gift to a man he has summoned. One who knows the revealed canon and is of good character. But anyway, the idea is that the father or the husband, or in this case, the state is the parent.
Parents get-
Yeah, the state has taken this paternalistic kind of jurisdiction and said that I am also her guardian, along with the husband and the father and any other neighbor, male neighbor, I don't know.
The second was from Manusmriti or the judgment.
The Manusmriti, the second one. Only the first para is from.
Can't distinguish on this.
Exactly, exactly. That was the point I'm trying to make. Only the first bit is from the first point is from the judgment. The other two are from Manu. Yeah. This one. These are some other stereotypes. Again. Okay. Guess again which one is from the Manu and which one is from the judgment.
First one is the judgment, second two are from the mind.
So the second one is also a judgment.
Okay.
Third one
Manusmriti doesn't talk about divorce.
How can a woman get out of
question.
Big question.
I was giving too much credit to mom.
So motherhood is a precious possession of a woman. And if perchance she is made to sacrifice motherhood, which is yet to enter upon, it is no less than suicidal death for a young woman. It sounds so much like a verse also, no? Like the language. Yeah, in this case, this one doesn't sound like a verse. The judgment sounds more like one. Whether husband is alive or not, a woman should be faithful to the man she married till her last breath. Divorcees too should maintain sexual purity to claim alimony. So even after a woman is divorced, and sometimes after divorce the maintenance case might be still be going on, and the court is still fixated on if whether she is sexually active or not after her divorce, whether she is engaging with other men to in order to decide whether she should get maintenance or alimony from her ex-husband. So okay, those were the examples that I wanted to give. And these are some solutions that we could think of. One is the gender stereotype handbook is. Oh, no, I'm just showing the handbook. Yeah. You can see, yeah, these are the various terms that have been used in terms of sexual offences mainly, but even otherwise also this is what the court is. The court has released this handbook and said that judges should refrain from using these terms, and also given what alternative terms could be used. So for instance, affair should be replaced with relationship outside of marriage. Career woman, now these are the stereotypes. She's a career woman, she socializes. The example that Sabha was giving, she's from the elite society and etc. Chaste woman is woman, huh?
Chaste woman.
Yeah. Is woman. Chaste woman. Dutiful wife, faithful wife, good wife, obedient wife. Should just be replaced with wife. Yeah. Again, why to ascribe a certain quality, a certain, the word wife always is coming with some sort of an imposition of the judge's morality. Woman of easy virtue is also just a woman. And there are also terms related to other gender identities. It's not just to do with the women.
Basically, this is character assassination.
Yes. Fallen woman. Forcible rape. Again, what is forcible rape? Rape anyway involves the idea that rape is something that is without consent. Hooker, sex worker, hormonal to describe a woman's emotional state. This is also something that the court does to say that because she's
Compassionate
hormonal.
or can I read that? Please
Yeah.
use a gender neutral term that describes the emotion. Example, compassionate is very cute. Chandu.
Indian woman, Western woman.
No, but I know one of India's foremost feminist lawyers was involved in making this. So while we can make sense, and I will not take her name, she's well because then because I worked closely with her, and I know for a fact that a lot of academicians were actually consulted in making this. There was a whole committee.
There's
This is
an
not this.
acknowledgement page.
So the very idea, please go up. This one, compassionate or enthusiastic. This is actually going back to what you said at the very start. Good benign stereotypes.
Yeah.
So what they are doing, they are shifting the scales for the woman itself by telling that you can use this but not this.
Yeah. Maybe that could. We'll have to see how even courts, if they manage to even use some of these words, which they're clearly not doing right now. But ravished is replaced by sexually harassed, assaulted, or raped, depending on what the offences are. That's the language of the offence, and ravished is a language that
I
is.
mean, for example, slut and woman. I mean, they absolutely have. They don't do that in the judgments. It is just that how things are reported.
Perhaps.
Yes.
Yeah. Woman of loose morals, easy virtue, promiscuous woman is also to be replaced by woman. And then there's also other stereotypes. Unmarried women are incapable of taking important decisions about their lives. Women of oppressed or marginalized communities have diminished cognitive capabilities or a limited understanding of the world. All women want to have children. So these kind of stereotypes are something that the court has suggested to be replaced. But despite this, you can see that now they have gone one step ahead and quoting overtly from the money. The other solution is to rely on better precedents that do exist, but they exist mostly in the realm of sexual offences, less lesser, I would say, in the case of family matrimonial cases. Like this case that, like the victim being a girl of loose moral character is something that one should refrain from saying has been promiscuous in a sexual behavior. She has a right to refuse to submit herself to sexual intercourse to everyone and anyone. No stigma like the one is cast in the present case should be cast against such a witness by the courts. For after it is the accused and not the victim of sex who is on trial. And that sums it up very nicely that basically through these stereotypes what the court is doing is that putting the woman through some sort of Agni Pariksha to check if she's lying or how she was dressed. So the other solutions can be what Ambedkar calls that we are still, back then he said, and maybe that's true even today, that we are a society that is so driven by customary morality. Basically a morality is something that we draw from our customs, Hindu customs, and we need to shift from that to reflective morality, which in turn, if for the judiciary could and should mean constitutional morality, right? So to basically reflect upon what traditions, so to say, we have been following and using as stereotypes, and reflect upon them, and to look at alternative models or rational models of morality that exist. Critical presence and representation of women in judiciary. This was a statement made by N.V. Ramana when he was the Chief Justice, that basically to highlight how women are so underrepresented in the judiciary. So again, when I say critical presence of women in the judiciary, it's preferably women who do not celebrate Karwa Chauth, who do not wear the sindoor.
Like people unlike Hindu Malhotra then.
Yeah, I guess. I'll come to that. Not Hindu, but Pratibha.
Okay, fair.
Yeah. So have critical presence of judiciary. Huh? Oh. Sorry, I'm being recorded. So anyway, critical presence of women in judiciary who themselves do not perpetuate these stereotypes. The other thing which is already there fairly pretty much in many precedents and laws etc. is to consider the asymmetry of power between a man and a woman, and to always keep that in mind when a judge is deciding something related to a sexual offense or a matrimonial issue between two partners or the rape accused and the victim. Yeah. So these are again some things that, drawing from theories, that even when women's rights are legally recognized in the abstract, long-standing customs prevent their full expression. So what these stereotypes are harmful in the way that they undermine the transformative potential of the law. The law is kind of ahead of people, and in the Indian case at least it has been like that the law has always tried to march ahead of the people's morality and the people's belief in faith, customs, etc. But the people are basically bringing down the law to their level, and that sums it up nicely. The other thing is to recognize intersectionality, which is basically that, for instance, if a marginalized woman has been raped, if a woman belonging to the SC/ST community has been raped, then that should be recognized properly under the SC/ST Act, which the courts do not do. The courts basically say that only if an SC/ST woman was raped on the ground that because she belongs to a lower caste, that was the only reason for the man to rape her, only then it will fall under that act. Now that is a very harsh reading of the SC/ST Act. Yeah, it doesn't recognize intersectionality, intersectional identities of a woman. So that's sort of a reading of the law, a very strict reading of the law, whereas it could have been read more constructively to give relief to the woman. Law again is not alone deciding the fate of basically the rights of a woman, rather transforming her claim for rights into a claim for duties or imposition of duties. And so therefore we need to question how far this human intervention in deciding upon women's rights. I don't know, maybe we should have AI judges or something like that. In the gender stereotype handbook, it's written that, the oath as judges mandates that they perform the duties of their office without fear of favor, affection or ill will. So, and this is to do with the fact that, one should not be deciding, this basically implies that one should not be deciding anything on the basis of some sort of stereotype, partiality, something that is already ingrained in their minds. Are supposed to read the law as per what the law circumscribes and not imposing your own ideas into it. Now again, we also need to recognize the fact that it's not possible to keep the person out of the thing that they are doing. So it also makes sense to promote a society where better people are generated, created, instead of just saying that you are supposed to read the law in this way or that way. Law is not something that is to do with the skill of reading the law, but it affects so many of our lives. So a more humane perception of the law, perhaps. This is something that I should not be naming, but that's not visible.
Oh, this one.
Yeah.
Okay.
Okay. So
Oh,
Indian.
this Pratibha.
Yeah, that's Justice Pratibha.
It's being recorded.
Yeah, we'll have to come back.
Justice.
Just saying with the comment, just go easy.
So Indian scriptures like Manusmriti give respectable position to women, and the Lord, and also this was an event that was about women in judiciary or something like that. So it had to do with women, and there are several other statements along these lines that were given by her, and also saying that a lawyer wife can make for a very good spouse, and many other stereotypes that she herself was indicating in a speech. This is not from not from a judgment. And she's like, wife should also sort of cannot sing. Just go and read it. So my basic idea is that we need to throw out the entire premise of Manu, and that is Manusmriti's statute from the Rajasthan High Court. Okay, and Ambedkar's statute has come only now in the Supreme Court. This is there since the 90s, I think.
1988.
Yeah, 1980s, yeah. So, and this was painted black by two Dalit women. So, now the comparison basically I'm trying to draw here is that we don't promote Hitler today because he was a good painter. We discard him entirely. And why is it that we're looking at Manu, looking at any sort of goodness in Manu and not discarding him entirely? So that was some comparison I tried to make.
Also, Hitler was vegetarian, dog lover, violinist.
Yeah. So, but then we're not saying okay now we are going to study his paintings or anything, right? And
His violin music.
or his music or anything like that. Then why are we looking at any?
See, also one thing, Manu per se was not one person as it
Yeah,
has been
yeah.
put out.
I
He was series of sages. These books have been written over a period of time and extrapolated together by long line of
But
histories
this is a
apparently.
representation
He
of.
codified them, like he is credited with.
My point is, Manu per se does not refer to one person. It
Yeah.
was a long tradition of people who wrote. I mean, they obviously made a statue out of him, but again, it has to go with how pathology of Hinduism is.
Yeah.
Also.
So that's about it. And 25 December is celebrated as Manusmriti Dayan Divas, and it is also said that this is Trimukti Divas for some good reason, which I've tried to show you why the Manu needs to be discarded, because it essentially propagates gender stereotypes primarily in the Indian context.
Okay, before we move into Q&As, I wanted you to speak about one thing, which is something that you've reflected in your article that you've written when the another judgment very recently had come out, where you spoke about. So basically, it's like you were saying while talking that the threshold for women is always high. Like if a man calls his wife bhoot or pishash, that's not cruelty. But if a woman refuses to like stay with the husband, not wear sindoor or bangles, that's like a ground for divorce, and the same ground, cruelty. So it's basically what you pointed out in the article, that predominance is given for wifehood and not womanhood. You've said it in like bits and pieces while you were presenting it. If you could just elaborate a little bit more on that, like what is this concept, why is it given more prevalence, and how it feeds into our judiciary and their and the thought process as well. They are deciding on cases where women have sought for relief.
I think I made that point, in bits and pieces.
Yeah, in bits and
also.
pieces. If you could just
Basically, that idea about how the woman as a mother and her sexual freedom was given more privacy before in earlier societies. Chandaman will be able to tell us better, he's the history guy. but later on, what started to happen was when patriarchal societies started to emerge, to restrain a woman's sexual freedom. Basically, there was no concept of monogamy and things like this before. To restrict her sexual freedom, the identity of the wife was given to her, and the monogamous identity of the wife, so that she's controlled, and also because of her inherent nature, which is wild and she's promiscuous, etc., etc., that her sexuality needs to be controlled in order to benefit the men in the society. Uh, that's the basic idea, that her status was sort of denigrated from mother to a wife, which is why the identity of a wife, sister, daughter, mother, etc. doesn't have that much importance in a patriarchal society, at least in India, as compared to a wife, because there's so much written about the wife in the Manu.
And another observation, while you were quoting examples, there was one place which said that even after divorce they should remain chaste.
Yeah.
There was a recent judgment which disallowed a woman to change her maiden name. Where the judge said that please go get permission from your ex-husband after you've been divorced to change your name from your husband's name to maiden name. So the courts do still look at women as properties of men, and that does not change with, say, like you were saying, that only laws cannot help.
Even though
women
she
with that.
stops being a wife, she's
even
still
though
a wife.
Correct. And she needs to take her ex. We don't even know where her ex-husband is now. Where is she going to go look for him? Like you were saying that law itself is not enough to help women out. Before the handbook came out, there were many instances where the apex court had told the courts not to be sexist. Like there was one instance where they said in 2019 that stop using these sexist remarks. Then the handbook came out. Then again recently there was a judgment saying that can you please stop using sexist remarks in your judgments, which is not okay for you to quote in your judgments. So we see a trend that either the judges don't understand or it is internalized so much in their minds that a woman has to be a certain way. So what do you have to say about that? Like what even with the solutions that are there, even with judicial academy trainings, even with that whole handbook, which is a very exhaustive handbook, right? Like it specifies each and every word that has ever been used in the history of judgments or may be used. So how else, where do women go then? Because we know that women don't approach courts as the first option. It's always the last thing. So even as like a, what do you say, without any recourse left, when the women approach courts and then the judgments are given in this manner, taking away their rights, what should the women do?
I don't know. The men can answer perhaps. What should the women, where should they go? That's what I think, critical presence of women in both advocacy, judiciary, and in various fields might start to bring about that change. I don't see any other way, and it's also with like the Domestic Violence Act, and so many laws came out because so many women had been protesting about it, writing about it, etc. When women brought it to the public discourse is when changes came about. So maybe more forcefully, if we are able to bring this into the public discourse, then something could happen. But we are all so busy on busy in scrolling reels nowadays. I think a lot less work gets done. Guilty of it. Yeah.
Alright, we'll open up for questions now from the audience. We are recording this. If anybody is not okay with being recorded, we can stop it and we can still have the Q&A now.
Yeah, I think we can have a clear Q&A.
Alright, we'll stop.
No, it's recorded. It's
No,
not live stream.
it is
It was live stream.
Yes
YouTube.
or no? What is that?
YouTube live stream.
No,
YouTube.
it's not gone live.
Yeah.
It's not gone live.
It's a recording.
You have to cut many things.
Oh, maybe.
Yes.
Absolutely. I have no idea.
Hari, you cut the part. Have you stopped?